case briefs, and so much more. LSData's got what you're looking for.
The United States Court of Appeals for the 11th Circuit heard a case in 2011, Glenn v. Brumby, where Vandiver Elizabeth Glenn, a transgender woman, claimed she was fired from her job as an editor in the Georgia General Assembly's Office of Legislative Counsel due to discrimination based on her sex and medical condition. Glenn argued that this violated her rights under the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. The district court ruled in her favor on the sex discrimination claim, but not on the medical condition claim. After Glenn began transitioning from male to female in 2005, she informed her direct supervisor of her circumstances. When her employer, Sewell R. Brumby, saw her presenting as a woman on Halloween in 2006, he asked her to leave the office. Both parties filed appeals to the United States Court of Appeals for the 11th Circuit, which declared that discrimination against transgender individuals is considered sex-based discrimination under the Equal Protection Clause. The court upheld the district court's judgment in favor of Glenn on her sex discrimination claim, stating that Brumby didn't provide any other reason that could qualify as a governmental purpose for firing Glenn due to her gender nonconformity.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.